Working with young people and your duty of care. Hi, my name is Annie and I'm a lawyer from Youth Law. Youth Law provides free legal information, advice and community legal education for young people up to the age of 25. We also provide information and community legal education for those who work with young people. If you work with young people, your legal obligations can include your duty of care, protecting a young person's privacy and confidentiality, and reporting child abuse if you belong to a profession who is mandated by law. In this session, I will outline what those legal obligations involved. Throughout the session, I will refer to case studies and frequently asked questions so you can see how these obligations work in practice. The people named and the situations described in the case studies are entirely fictional. Please note the information provided in this session is intended as a general guide only and it is not legal advice. You should seek legal advice about how the law applies to your own particular situation. The information in this session is based on the laws in Victoria as at August 2012. Young people and your duty of care. What does it mean to owe a duty of care? A duty of care is a legal requirement to take reasonable care to protect another person from a foreseeable risk of injury. If you work with young people, you will generally owe your clients a duty of care. Depending on the situation, you might owe a duty of care to others who come into contact with you or your clients while you're at work, such as your co-workers or members of the general public. If you owe someone a duty of care, you have to protect them from foreseeable risks of harm. A foreseeable risk is a risk that is not completely unexpected. For example, if you take a group of young people rock climbing, this activity involves a foreseeable risk of injury. If you identify a foreseeable risk, you must take reasonable care to prevent it from occurring. The law doesn't state what reasonable care involves in every situation. It will depend on the circumstances of each case. What amounts to reasonable care can depend on a number of factors such as your training, experience and qualifications. For example, the standard of care that is expected of a team leader is higher than that expected of a staff member in training. The relationship between you and the young person. How well did you know the young person? And how closely did you work with the young person? The age and capacity of the young person. For example, if the young person has an intellectual disability or a health condition, the standard of care might be higher. Agency policies and procedures. Were there policies in place regarding, for example, minimum staffing numbers or first aid training? Budget and resources. Was it difficult or impractical for you to reduce the risk? Let's consider the following scenario. Vera is a youth worker based at a youth drop-in centre. A regular client, Dan, had come into the centre earlier that day, but Vera had told him to leave the service because he seemed drug affected and he was acting inappropriately. Dan went outside to stand on the steps leading into the service, where other young people often hang around. He started play fighting on the steps with some other boys who were there. Vera sees this, but she was busy with other things, so she doesn't intervene. One of the other boys on the steps reacts over aggressively and punches Dan. Dan stumbled backwards at a spot where the railing had been taken off by vandals and had never been repaired. Dan ends up falling and hitting his head. To whom does Vera owe a duty of care? In this situation, Vera owes Dan a duty of care as a client of her service. She may also owe a duty of care to others, such as the boys on the steps or passers-by. Even if they are outside the perimeter of the youth service, her duty of care may be more limited, but it still exists. Did Vera show reasonable care? There are no black or white answers. The question is, what would a reasonable person have done in Vera's situation? What is reasonable might depend on factors such as Vera's level of experience, the youth centre's policy and procedures, the centre's resources such as the level of staffing. Did she know Dan well and could she have predicted this might happen? Also, how dangerous was the damaged railing and did this make the risk of someone falling, like Dan did, more foreseeable? Things to consider are whether, for example, someone had fallen in the same spot before. Another factor to consider is Dan's age and other circumstances. If Dan was younger, say 12 years old, or if he had an intellectual disability, a higher standard of care would be expected of Vera. What about the fact that Dan seemed to be drug affected? The fact that Dan was drug affected may make the risks more unpredictable, but it might also mean that Vera owes a greater duty of care. If a young person is drug affected and you have concerns for their safety, your duty of care may extend to providing first aid or contacting an ambulance for help. Was Vera right to ask Dan to leave? There may be situations where you have to ask a young person to leave your premises if they are drug affected. For example, you may need to ask them to leave to protect other young people at your service because you also owe those young people a duty of care. Should Vera have intervened when the boys started fighting? If someone on your premises is acting violently and you intervene, there is a high risk that you will be injured. Your agency's policies and procedures should provide clear guidelines about what you should do in this situation. These policies should be based on occupational health and safety laws. In general, you should warn the person who is acting violently to stop the behaviour, or you will call the police. Try to ensure that other people, for example other clients or staff, can safely leave the area if someone starts acting violently. If you feel that you would be at risk by intervening, you should not become involved. You should maintain supervision of the scene from a safe distance until police arrive. Should Vera have contacted police about Dan using drugs or Dan being assaulted? You are under no legal obligation to report a crime to police. Police may come and ask you questions about a crime if they think you witnessed an offence. If the crime was serious, like assault causing injury, you must give police your name and address, but you're under no obligation to make a statement or provide them with any further information. However, you do need to be careful that you are not hindering police by stopping them from carrying out their duty or assisting someone else to commit a crime or evade arrest. If you do, you may be charged with a criminal offence yourself. Your workplace may, however, have policies and procedures around when you should call police that you are required to follow. What if a young person injures themselves by behaving recklessly, for example by taking drugs or play fighting? If young people knowingly put themselves at risk, your duty of care to them may be reduced. However, if you are working with vulnerable and at-risk young people, it is reasonable to expect that you and your agency have policies and procedures in place to minimise the risk of harm the young person could cause themselves and others. Could Dan sue, and would he sue Vera or the youth centre? Although it is rare, you can be sued if you breach your duty of care to a young person and they are injured as a result. An injury can include not only physical injuries and illnesses, but emotional harm. If Dan sued for negligence in court, the court would need to decide whether a reasonable person acting in Vera's position would have foreseen the risk of Dan being injured, and what reasonable steps they would have taken to avoid the risk. If a person is injured in a situation like this, they are more likely to sue the agency, in this case the youth centre, as the centre will have insurance policies to cover compensation payouts. If a case goes to court, Vera may be called as a witness to give evidence. However, individual workers like Vera can also be sued. Employees will generally be protected from being sued as long as they follow agency policies and procedures, and relevant laws such as occupational health and safety requirements. There is no guarantee that the agency will cover your costs and expenses if you are sued. Check your employment conditions to see whether your employer will indemnify you against liability. If your interests and your employer's interests differ, you may need to seek your own separate legal representation. Frequently asked questions. What is your duty of care if you drive a young person somewhere? As workers, you are liable, just as any other driver is, for injuries caused to someone who is a passenger in your vehicle. If you have an accident while transporting a young person in your car, you are liable and you can be sued for any injuries. However, you will generally be indemnified by the TAC if a compensation claim is made. If you are going to use your car to drive a young person somewhere, it is wise to check with your agency whether you are covered by their insurance and whether they'll reimburse you for damage caused to your car or to other people's property. If not, you may have to cover any expenses. Can you be held responsible for a young person's actions once you drop them off? There is no simple answer to that question, and it may depend on the circumstances. Once a young person has exited your car, you are not usually responsible for their actions. However, if you give a lift to someone who you know or you believe is going to commit a crime or has just committed a crime, and the lift helps them in committing that crime or escaping from police, your actions may be construed as aiding and abetting the crime, which is a crime in itself. What about your duty of care on camps and excursions? You owe a duty of care whenever a young person is in your care, and that includes taking them on excursions or going on a camp. You should think about the following issues. Be satisfied that the venue and any equipment you will use is safe. Be clear about any equipment the young person needs to bring along, including clothing and footwear. Know the environment, for example, the degree of difficulty of a hike. Know the capacity of your clients. For example, do they have the required fitness level for an activity? Carry emergency numbers for each young person. Bring along first aid equipment. Consider staffing levels and supervision. Do you have sufficient supervision and staffing levels for the number of young people you're taking along? Greater staffing levels or trained supervision should be provided if you have clients with special medical needs or if the event involves a particularly risky activity. Do you have signed consent forms and medical forms? If you are taking young people on an excursion or a camp, you should collect a medical form and consent forms, which include information such as current medications, previous illnesses, allergies and disabilities. You should make sure all staff are aware of this information. The consent form should also state that the young person is allowed to receive emergency medical treatment and use an ambulance. It is best practice to get parents or guardians to sign this form for a young person under 18. But if a young person does not have a parent or guardian in a position to sign a form, you can accept the young person's consent as long as they're capable of understanding the risks and what the form is for. Be aware, however, that a signed consent form will not necessarily protect you or your agency from a negligence claim. It will not protect you if your behaviour was careless or you failed to prevent a foreseeable risk of injury during an activity on a camp or an excursion that consent was provided for.